Hello everyone, dear colleagues and friends in Brazil and from Russia. So my name is Sung Ko. I am professor of law at Seoul National University in South Korea. So first of all, I should say sorry that I could not attend the conference which I should have attended. As you all know very well, the the globe is heavily inflicted by coronavirus. So among them, South Korea is one of the most heavily affected country. So that's the reason why at the last moment I better not to go there, because not in any one chance I wanted to make you feel any inconvenience or uncomfortable. So that's why I couldn't go to São Paulo at the last moment. Uh, the the topic I prepared for the conference was public procurement and fraud in Korea. So if you can refer my presentation material, so you can follow the page numbers that I mentioned while I speak. So my talk is composed of 7 sections. Among them, I will some of them I will focus more deeply, and some of them I will give some brief overview and skip over. The section 1 is the overview of procurement law in Korea, which is at the page 3 of my presentation. On Government Procurement Act and Act on Contracts to which the state is party, these two are the major statutes governing procurement procedures in Korea. So other than that, we have Defense Acquisition Program Act or Act on Contract to which the local government is a party. First, let me go to Government Procurement Act. I will call GPA from now on. So the purpose of this act is to ensure public procurement services efficient performance while taking into account its public character. And its article is including about issues like scope of government procurement contract, social responsibility of GPC, quality management, special cases for contract, price payment, fees, procurement procedures, etc. The next act is Act on Contract to which the state is a party, so-called State Contract Act. So I will abbreviate it as SCA. The purpose of this act is to promote smooth administration of contracts by providing for basic matters regarding contracts to which state is a party. And it is having articles about scope, principle of contracting, integrity agreement, a method of contracting, public tender, competitive tendering procedures, payment of price, penalties for the inappropriate business entities in tendering procedures, state contract dispute committee, etc. And in the section 2, so I briefly dealt with the issues of legal nature of GPC, whether it should be understood as public activity or it can be just dealt as private activity, so about which just private law can be equally applied. And I will skip these sections. So let me go to section 3, public procurement and fraud in Korea, more focused on statutes. GPA Article 3-2 is about increasement of social responsibility. It is prescribing like this. In order to increase social responsibilities of enterprises, the administrator of public procurement service may reflect social and environmental value, such as environment, human rights, labor, employment, fair trade, and consumer protection in the procurement procedures. So the next is GPA Article 9-3, which is about investigation into unfair procurement. And let me go to State Party Act Article 5, which is about principles of contracting, which is prescribing like this. A contract shall be concluded by agreement of parties to the contract on equal footings, and the parties shall perform terms and conditions of the contract in good faith. And SPA Article 5-2 is about integrity agreement. It is prescribing about so-called integrity issues on the process of procurement agreement. And SPA Article 5-3 is about cancellation, termination of contracts when the fraud issues happens in procurement procedures. So let me go to section 4 on page 18, which is about procurement and fraud in Korea, more focused on cases. So in these sections, I will introduce one interesting Korean cases, which is about military oil procurement collusion case. And this was done in the 3 layers of court decisions. So the first one was Seoul Central District Court decision, which was delivered in 2007. And this case went to High Court and Appellate Court and the decision was delivered on the year 2009. And this case go to the Supreme Court and the decision came at the year of 2011. Let me go to fact. So in this case, the plaintiff is Republic of Korea, especially the Ministry of Defense is the party in charge of these issues. And the defendants was petroleum companies like company SK, GS Caltex, SO, Hyundai Oil Bank, SK Incheon Petroleum. So the major petroleum companies in Korea. And the plaintiffs, the Ministry of Defense was procuring military oil from these defendants' companies. From year 1998 to 2000, in every year procurement procedures, defendants concluded the process of bidding and got contract with plaintiffs according to the pre-concluded shares of each company. Fair Trade Commission of Korea, KFTC, found out this illegal collusion of defendant companies and levied quite heavy administrative penalties. And plaintiffs, the Republic of Korea, raised civil tort suit against the defendant companies, claiming that the illegal colluded actions of the defendants are fraud and inflicted damages as much as $1,500 million in total. The issues in this case is as follows in page 22. The fact findings and illegality of the defendant's collusion was without arguing because these issues were verified at the process of KFTC. The main legal and factual issues in this case was how to calculate damages. So the damages in Korean tort law is like this. The monetary disadvantage from illegal tort activity, or the difference of plaintiff's monetary status between before and after of the illegal tort activity, or the difference of plaintiff's monetary status between the status plaintiffs would have got, but for, if not, the illegal tort activity and the real status after tort. And the main issues in this case was how to calculate the damages, how to find out the ways to calculate damages. And the two main methods of calculating damages were provided during the trial process. The one is MOPS, or means of plate Singapore yardstick methods. So this is basically comparing the price of the colluded activity at the time, the price at the Singapore plate market, and by comparison of the Singapore price and the colluded prices, the difference can be the yardstick for calculating the damages. So the other one is MRA, multiple regression analysis. So this is more statistical regression of but for prices. So this is try to find out the hypothetical prices if the defendant's companies did not collude about the prices. So by using the economic method of regression. So this is kind of economic analysis of law. At the district court level, so the court took finally MRA. The court ruled that economic analysis and statistical analysis like MRA is the more scientific reasoning to find out legal solutions. After comparison between OLS, which is ordinary least squares method, and WLS, which is weighted least squares method. So the court took WLS and built up its own analysis after considering plaintiff's and defendant's analysis report. At the appellate court level, the court still accepted the reasonableness of economic analysis, including MRA. However, the judges at the High Court doubted the validity of the normative estimation of judges about the economic analysis, especially whether it is appropriate for the judges themselves to modify the analytical model itself, or the judges themselves can control the variables which are critically used at the regression process. And in that stream, the appellate court rejected MRA and took MOPS on comparison method. And this case goes to Supreme Court. And the judges at the Supreme Court rejected High Court decisions on the ground that the MOPS method is not an optimal method in calculating damages in this case. MOPS is based upon the assumption that Singapore oil market is working almost under perfect competition conditions, but Korean oil market is under quite different situation. So this kind of simple yardstick comparison is not a good way of calculating damages. And the Supreme Court requested that it is needed to develop a more sophisticated method of calculating the damages. And this case was remanded to High Court again. At the remanded High Court, so this case was solved by settlement between the parties. So it is somewhat regrettable. So no additional legal deliberation has developed, not anymore, and this case was summoned as such. So this is the brief overview of statutes and cases on procurement process and fraud in Korea. At the section 5, this is legal framework for understanding GPS. So in this section, I try to look into or understand the procurement process more theoretical or more academic perspective, like public law theory or public interest theory and public choice theory. This is quite interesting topics, but I'm a little bit worried. So this is going too much academic or theoretical. So I will skip this section too. And I'll go to section 6. And this is about government contract and private autonomy, which begins from page 33. So in this section, so I try to summarize and introduce some recent Korean Supreme Court cases, which is about how much private autonomy principle can be governing in government contract or procurement process. So in this case, the issues were like this. At the page, you can refer page 37. So first one, so what is the legal nature of government contract? So whether it is private or public. And what is the legal nature of SCA Article 19, so which is prescribing about the modification of terms due to unexpected kind of economic change or conditions. So whether this article is mandatory or suggestive. And third, the validity of the private contract, which is against the contents of SCA Article 19. So whether it is valid or it can be still, it can be void. The fourth is the purpose of SCA Article 19. So whether it is to protect the private parties or it is to enhance the efficiency of welfare maximization of the market or the community as a whole. And in this case, the Supreme Court judges were divided into two groups, majority groups and minority groups, and quite interesting discussion and deliberation has been going on, and quite insightful our conclusion has been provided by the court. So this is about the case, and this is section 6. And finally, section 7 is concluding remark and Q&A. Yeah, if I were at the conference venue myself, I think I could have quite interesting Q&A sessions with you, but unfortunately, I cannot do this time. So this is the topic and discussions I prepared for the Sao Paulo conference. Sorry again that I could not be there by myself, but please give me deep understanding that this decision was not to make you feel any uncomfortable. So thank you very much, and hope to see you again, whether in Brazil or in Korea or in Russia. Thank you very much.